Hey everyone, this is Aditi and you're watching Legal Bites. Our today's topic of discussion is trespass to land. In this video, I'll be looking at the introduction to trespass to land, meaning of trespass to land, how trespass to land can take place, kinds of trespass to land, followed by defenses, and at last but not the least, remedies. Now let's start our video. Coming to our first topic, that is introduction to the trespass to land. Trespass to land refers to the wrongful interference of one over the property of another without any legal justification. It should be direct and physical. Now coming to the meaning of trespass to land. Trespass to land occurs when an individual enters onto another individual's land without their permission or without any legal right to be on the property. Trespass to land is one of the oldest actions known to the common law and can be defined as an unauthorized interference with a person's possession of land. Now coming to our next topic, that is how trespass to land takes place. It must be shown that the defendant entered into the property. This can be done through negligently or intentionally. In some states, even if the defendant entered into the property by mistake, it is still considered to be trespassing. The land must have belonged to another individual in order for the action to be trespass. The claim must be brought against an individual who does not have a legal right or claim to enter the land. It must be shown that the defendant did not have consent to enter onto the land, neither expressed nor implied. In other words, the defendant's entry onto the land must be unauthorized. It must be shown that the defendant has caused damages to the plaintiff. However, it is not required that the defendant intended to cause harm. Instead, it must be shown that the defendant's action was a substantial factor in bringing about the harm that the plaintiff suffered. Now coming to our next topic, that is kinds of trespass. There are several ways of trespass to land, such as trespass by wrongful entry, trespass by airspace, continuing trespass, and so on. Now coming to the first kind of trespass to land, that is trespass by wrongful entry. This occurs when a person enters onto someone else's land without the due permission of the rightful owner, or when a person refuses to vacate the land when the permission to enter the land is withdrawn by the owner. There has to be a contact with another person's property to form this trespass, however slight it may be. Examples of this kind of trespass are encroachment on the land and walking through it. When the permission to entry is granted by the lawful possessor of land is abused, it also qualifies as trespassing. For instance, in the case of Bond versus Kelly, Kelly was found to have committed trespass because he had acted outside his course of employment. Kelly was commissioned to deforest a section of land on Bond's property, and therefore Kelly had lawfully licensed to enter onto Bond's property. However, Kelly had cut down more trees than ordered and thus was found guilty of trespass despite lawfully entering the property. Now coming to our next type of trespass to land, that is trespass to the airspace. Legal maxim quid pros infra defines land as land includes not only the surface and any buildings on it but also the subsoil and airspace insofar as these are vested on the plaintiff. Therefore, intrusion into the airspace at a relatively low height constitutes the tort of trespass to land. In the leading case of Smith versus New England Aircraft Company, in which the courts held that flights up to and below an altitude of 100 feet of a property constituted trespass to land, the court further held that low-flying airplanes created a nuisance and disturbed the owner of a land from enjoying his or her use of land and interfered substantially. In the leading case of Dido versus Alberta Power, the court once again explored the heights to which the owner of the land has the right to airspace. Now coming to our next type of trespass, that is continuing trespass. Continuing trespass is a repeating or ongoing trespass, especially onto the real property. The best example for this form of trespass is the case of Holmes versus Wilson. In this case, the defendant erected buttresses to support a sinking road necessitating trespass onto the claimant's land. Holmes sued for damages and recovered them successfully. However, when the defendant failed to remove the buttresses, he sued them again. Now coming to defenses against trespass to land. The first defense is consent. Consent is the most common defense against trespass to land. The defendant can argue that the owner gave them permission to enter onto the land. It is important to note that the consent may be given with words or actions. However, the defense will not be applicable if the consent was induced by fraud or was given by a person who was incompetent, intoxicated, or a minor. The next defense available is of license. The defense of license implies that when a person has obtained permission from the owner of the property, then he cannot be liable for trespass. However, the defense of license is valid only till the terms of the license are not exceeded by the person entering the property. And if he or she exceeds or misuses the license, then they can be held liable for trespass. The next defense available is of necessity. Necessity can be used as a claim to show that it was necessary for the person to unlawfully enter a piece of land that did not belong to him or her. In such a case, the liability of trespass may not arise. The next defense available is the doctrine of estoppel. It is a very essential component of defenses to actions of trespass. Estoppel is a legal principle that restricts a person from making allegations or denying the facts owing to their previous conduct, allegations, or denial. The next defense available to trespass to land is justification by law. Any act which would otherwise be considered as tort under trespass to land is not trespass when so provided under the law. In the leading case of Elias versus Bashmore, where two policemen entered a premise to arrest a person, while there they took custody of many documents. Some were taken lawfully and others were taken unlawfully. Here the court said that the two policemen were not in trespass to land as they entered with a valid search warrant. However, there was a trespass to goods as they collected the documents, but they cannot be held liable for trespass to land on the basis of unjustifiable seizure of goods. Now coming to our next topic, that is remedies. There are a number of remedies that can be availed by the sufferer against the tortfeasor in the tort of law. The first remedy is injunction. An injunction can be issued at the discretion of the court to prevent further trespass. An injunction is a writ granted by the court of equity where one is required or restrained from doing a specific act. The court can order the trespasser to move from the owner's land in order to prevent further trespass, and if the trespasser continues to remain on the land, it will constitute a continuous trespass. Now coming to our next remedy, that is expulsion. The lawful owner of the property has a right to evict the trespasser from his or her property. If the trespasser refuses to leave or vacate the premise, then the owner has a right to use force to remove the trespasser from his property. But the force used cannot be exceed from more than what it is required to remove the trespasser. Now coming to our next remedy, that is action for mesne profit. Section 2, Clause 12 of CPC. Apart from the right of recovery of land by getting the trespasser evicted, a person who was disposed of his land may claim for compensation for the loss he has suffered during the period of disposition. Mesne profit refers to the profits taken by the defendant during the period of his occupancy. Hey everyone, if you find this video useful, do like, share and comment. We'll meet with the next video very soon. Till then, bye bye. Thank you.